Department was represented at the hearing in this case. I was here as a representative at the first hearing of this case. And based upon the order of determination by the task force, the sheriff did file a notice or petition for reconsideration of the two determinations that it found, that this task force found that the Sheriff's Department violating the Sunshine Ordinance. The two different violations are, the first one is 67.21A, which found us in violation of not providing Mr. Garza with video retention policies. The question with regard to that, in the request, as I mentioned in the petition for reconsideration, in my argument to this task force, and in my memorandum in support of the reconsideration, was that Mr. Garza's request was for records as they related to an incident of his arrest at San Francisco General Hospital on a specific date and time. With regard to that request, we were complete and timely in our response to him. The Sheriff's Department, although has access to video at the hospital, since we're the security there, we do not control or maintain the video equipment there. That is contracted through the hospital itself. However, I did learn through my investigation of this case that the video that Mr. Garza was requesting was no longer available. I learned that from hospital representatives. That information was made known to Mr. Garza and made known to this task force at the time I appeared. Based upon that, there were no video retention policies to share with Mr. Garza. Instead, I told him to please contact General Hospital for those that are under their control, the video policies. However, my understanding from the determination is that this task force found a violation of the Sunshine Ordinance because the Sheriff's Department did not provide Mr. Garza with retention policies for videos at other sheriff's facilities. And this, I believe, is an error of, or beyond what Mr. Garza asked for. It was not relevant to his request, it overreaches his request, and was not known to the Sheriff's Department that that's what he was asking for. Therefore, I believe that the task force's decision with regard to that violation is beyond the facts and beyond the request of this case. I'm asking on behalf of the Sheriff's Department to rescind or reconsider that decision. The second decision by the task force was in relationship to section number 67.29, the Sheriff's Department failure to properly maintain the Index to Records website. This is a jurisdictional issue. There was no complaint made by Mr. Garza or any other individual or agency that the Sheriff's Department maintenance of Index to Records was a problem, if there was any type of concern with regard to that. Basically, what I'm saying is that this task force does not have the ability that I'm aware of to just come up with a complaint sua sponte, without any type of notice, without any type of formal complaint procedure, find a complaint, bring in their own evidence at a hearing, and convict a department or agency of violating the Sunshine Ordinance when there's been no complaint and no evidence presented. The only evidence presented in that case, mind you, there's no complaint to begin with. The only evidence presented was a task force member or more going online, looking at the Index to Records during the hearing and saying that it wasn't up to date by the Sheriff's Department. That's not proper evidence. That wasn't submitted to this task force to look at or determine in that hearing. Therefore, I believe that this task force, in its determination, overreached its authority and jurisdiction in finding a violation pursuant to the Index of Records. I'm happy to answer any questions if you have any with regard to these arguments.
Thank you. I believe DCA, Cola, would you have some comments on this matter? Actually, hold on one second. Mr. Kirk, should we give the complainant an opportunity to talk also?
Yes.
Okay, my apologies. Take that later. Mr. Garza, would you like to say a few words?
Oh, I'd like to say a lot of words. First of all, I find it truly distasteful that, it's even being voiced for reconsideration. You guys are the judges. They have the ability that I have, if I don't like your decision, to, go to civil court. I think that that's what you guys should do, is have them go to civil court, just like when you guys rule against people, in our favor, let's say, for example, what Mr. Grossman had to do, and take people to civil court to get the Sunshine Task Force, law enforced. Secondly, for him to get up here and to espouse, that you guys couldn't rule on the index of records, nowhere in the ordinance does it say that you guys can't find other violations. This is your job. Thirdly, when he got up and he said that, it was complete. Complete. I never got the videos. As a matter of fact, I've still never even gotten the policies. Complete? What does that word mean? You're being bamboozled by lawyerese. You're being taken advantage of. This is the sheriff's department that, when I went to go follow up on the policies, I was never given an opportunity to speak with Mr. Nico, even though I have several videos on YouTube of me trying to follow up and do everything correctly. Oh, it's amazing how, the goalpost is being moved here. You guys are being told, oh, well, you can't do this, you can't do that, due process, etc., etc. All my due process was violated. I showed you the video of where I went in and, walked out in handcuffs, simply seeking my medical records. And of course, naturally, I even asked when I was being detained at the sheriff's place there at San Francisco General, whether those videos that I was watching through the next cell were being recorded, and I was told yes. And then for them to say that they don't have the videos and they haven't even come up with the policies for retention? Oh, please, folks. Are you here to advocate for the citizen? Are you here to bend over backwards for people who've already been found guilty by you? Let them go to court. Just like you'd have us do when you guys make a mistake or an incorrect decision. Shall I bring up the Mr. Grossman case and the ethics and how you guys never get anything enforced in ethics and how much of a farce that is? As a matter of fact, I heard something, in the past about, maybe truncating the services for us serial litigators, i.e. somebody like me, who's brought the Department of Public Health up repeatedly, and it's been repeatedly found in my favor, but yet the serial violators, the Department of Public Health, oh, well, maybe we should allow them to continue to break the law willy-nilly. And, speaking of breaking the law, remember what I told you guys about precedent. We're going to go all through this all over again for medical records because you guys don't set a precedent. So don't set a bad precedent here and bend over for the sheriff's department, who is only security there when my legal, medical, humane, and every other rights have been violated. And all I'm seeking is what I need to defend myself, to represent myself here at the Ministry of Sunshine, where apparently sunshine is very opaque. Depends on the interpretation of the law, who's given it, what fancy dress they're wearing, but certainly not for the citizen, because like I said, you can go to YouTube and you can see many times where I've tried to follow up with the sheriff's office and not been helped. As a matter of fact, I've been thwarted. So that's my piece on this. That's what I have to say. And, once again, you guys, do the right thing. And I'm a little upset that there aren't a full board here, because as far as I'm counting, there's 2, 4, 6, 7. The majority of 7, I believe, is 5, not 6, maybe 4. So once again, there should be 4 people ruling in my favor to determine this instead of, 6 that are required under another law that doesn't follow due process. Since we're talking about due process, and since that's what the sheriff's bringing up, I figure I might as well throw in my comments about how this is all set to fail and, how there's no accountability. And let me ask you one more specific question. How many ethics commission stuff that you've sent up has actually been, found in favor of? As a matter of fact, I believe it was the BAR that wrote an article that said it's the 16 or 14 times that you guys have sent something up to ethics. It's been a failure. So I've brought this up in the past. I'm glad I'm here to continue to speak the truth to, what I consider sycophants. But that's my opinion. Let's see the performance and let the public judge based on the performance or lack of it thereof.
Thank you, Mr. Garza. And may I just suggest that you keep a definite tongue in your head this evening? We'll be hearing a lot of your cases.
I'm sorry, definite
The
what?
reason that we're hearing this case, I'm not asking you a question, I'm just telling you.
I didn't hear what you said. A definite what?
You can just step aside and just listen. Be deferent to the people around you, including us.
What does that mean?
That means be respectful and polite.
Isn't telling the truth being
I'm not asking
respectful and
questions,
polite?
Rhetorical statements, don't answer.
Well, then I don't understand. How can I,
So. this
do
is the
something
correct-
that I don't
This is
understand?
the correct process for appealing an order of termination.
Correct.
I'm going to get to the heart of that. But if you give us a chance to do the right thing, we'll be much more likely to keep an open mind. So please do.
And if I tell you that you failed in the past with the truth,
All right,
I believe that's the
excellent.
utmost respect. Thank you.
Thank you. Mr. Clerk, should we go with Mr. Cola's summary next? I believe, I think there was an analysis that you did several weeks back when this first came up. That rings a bell. That gives good background, I think.
I mean, essentially what this does boil down to is a due process issue. I think the task force could come up with any potential charges within the realm of possibility for a particular complaint. But then you have to consider whether or not, the 67.29, the failure to keep an index of records, whether or not spontaneously raising that issue during that particular meeting, if that would have affected the sheriff department and who they sent to explain or to respond to that particular complaint. And again, regarding the other issue on the 67, I believe it was 2-1 issue. My recollection of that hearing was that the complainant did submit records or did submit some documents in support of his claim, and the testimony didn't really reflect the documents that he had. So I think moving forward, we should really put an emphasis on the actual tangible records that we have in support of all arguments in these cases. In particular, right now, I think both sides make compelling arguments, and I don't want to offer a ruling in either way or sway anyone's opinion on it. I think you should consider the evidence before you in this particular hearing and make your own determination.
I think in particular what I was referring to, DCA was more our process for reconsideration or determination. What's required? Have those requirements been met? Is there any new evidence that justifies this, etc.? That's the end of it.
We don't really have a set out protocol for reconsidering a determination that we've issued at the moment. That being said, I don't think Robert's rules would forbid it. I think thus far treating it as if it's a normal complaint is an acceptable process, but it might be something we might want to consider as a bylaw amendment moving forward. I think we can move forward as is, as long as we just keep in mind due process and affording both parties, a fair opportunity to present their case. But laying out an exact protocol in the bylaws in the future is something that I highly recommend.
Okay, I think that's something we have to do. I was under the understanding that evidence of new information would then allow a case to be considered. That I thought was in our bylaws.
Did we hear any new information right now?
Let me open this up to the members of the task force.
So I've been thinking about this a lot, along with being sick. You asked the right question, Acting Chair. I don't believe the bylaws speak to it, nor do I think they need to. I think it's the complaint procedure. And Victor, if you can pull up the section of the complaint procedure that speaks to reconsideration, I'm trying to figure out what the standard is for reconsideration, because we haven't had a request for this in a while. I'm trying to figure out if the request meets the standard. So that's one area. The other area we've touched upon a little bit hearings are actually due process hearings, and if that requires notice and the opportunity to respond and weigh evidence and all of that, I don't know. And it may be that some of our hearings are, if we're considering referral ethics, and some don't. It's an interesting question, and it's one that I think we need to figure out. And I think Mr. Nico's arguments are interesting. I'm not sure where I go with them. And so I need to have a better understanding of both our standards for reconsideration and this question of whether due process is required for hearings. And then
Okay, on that further, I think, Clerk, you have that section, so just read it out to refresh.
Yes, our complaint procedures state the following. Reconsideration of task force findings. Within 10 days of receipt of the order of determination, either the complainant or respondent may petition the Sunshine Ordinance Task Force for reconsideration only if information exists that was not available at the time of the hearing, and the petitioning party must present an offer of proof as to the new information.
That's pretty clear cut. Okay. Member David?
Is there any new information today that was not presented previously?
There are two issues. One is 67.29. There is not new evidence because my argument with regard to the task force finding on that case is based on the evidence presented. So no, there is no new evidence with regard to that.
Okay, so I just want to try to understand your position. So what you're saying is that you do not feel that there was significant evidence to find a violation of 67.29 when the task force found that violation.
Correct.
Is that your position?
Correct.
So but there's no new evidence. You're just saying that that's your position. Then you said there was a second point.
The second point is the 67.29 with regard to index of records. There was no evidence presented with regard to that issue.
Okay.
There's no new evidence because there's no evidence to even base that decision. My concern with the finding of that violation is that the task force was beyond its authority and jurisdiction in even considering that violation because it was not a valid complaint and because there was no evidence presented on mine.
So in my opinion, you very possibly could be correct on both points, but the way that I just heard the reading of our rules as to reconsider, that neither of the points that you're making, which could be 100% correct, would allow us as a task force to rehear and reconsider that case. And so, I think I'm going to vote to not rehear this, and that, as Mr. Garza said, you obviously, and the Sheriff's Department has the right to make that argument to the next level.
I appreciate that. Again, I want to reiterate that this is a concern with regard to following your rules. I understand that. But let's be consistent in how those rules are enforced. I pointed out in my argument that this task force neglected many of its rules in order to find these decisions. And because of that, we're here for reconsideration.
And I want to also be clear that I think that is a very fair argument. And, I wish it was one that we would have considered at the time of the original case. But I think that, to me, there's a much higher bar that needs to be reached to reconsider a case. Right? At the original case, I think that argument would have been made at the time, and we might have been able to address it at the time. But at this point, I don't want to set a precedent that without new evidence being presented, that we're going to rehear cases. Once again, we as a task force could have absolutely been incorrect in finding that violation. That's not what I'm arguing here. What I'm arguing is that what we are here to consider is the reconsideration of the case that we've already decided. And to me, it doesn't meet that standard because there is no new evidence to be presented.
Member Nico, in many cases, the task force is within its purview to find violations above and beyond what was brought by the original complainant. Many times the complainant doesn't know the scope of what else is within the Sunshine Law. So many times we've gone past what the original complaint was because we're here to enforce Sunshine, not particular one plaintiff's case against another. That is our charter. And as far as the evidence not being there about the index of records, that's because the index of records was not presented to Mr. Garza. And that would have been something that further information on that, so that argument kind of falls as well. So I'm afraid I'm leaning towards David's position on this. I think, new information and proof within that 10-day period would have certainly held water as far as reconsideration, but I don't see that in this case.
There's one concern I have with regard to that rationale.
1 second. I'm going to give, we're going to talk a little bit more. Is there any more discussion with the task force? Then I'm going to give both sides a chance to summarize.
Don't I get to say something?
I said both sides to
Thank you.
summarize.
So, Mr. Nico, you don't have to answer this. If the task force denies your request for reconsideration, are you at this point likely to respond and appear at the committee meeting, or are you considering an intergovernmental action against the task force on this question of authority?
That hasn't been decided yet, so I couldn't answer that.
Okay. I mean, I don't know how big a deal this is or how big a deal this could be. I would rather that we try to figure this out and avoid litigation if that's a possibility here. So I'm kind of torn on this, and I would still like to hear more from DCA on this question of whether due process attaches to our hearings. I'm still unclear about that. And for me, a lot of this decision turns on that.
Personally, I'm of the school about that due process doesn't attach to administrative hearings. I think if a party to a complaint here were to actually file a court action to overturn something in the Superior Court, that would be the standard. They would say, were the parties to that complaint afforded due process in their administrative hearing? Because of that, I think we should hold ourselves to that standard.
Well, then in response, if you go with that line of thinking, then due process in an administrative hearing requires charges and the opportunity to rebut and present evidence, and the decision makers have to consider the evidence. As Nico suggested, an additional charge brought, what's the term, sua sponte, doesn't offer the respondent in this case the opportunity to present the facts and evidence to rebut.
Well, it seems as if in order to afford more due process, there needs to be a bylaw amendment that allows for a more broad interpretation of what we can reconsider. As it is right now, there's no procedure for us to hold a hearing unless there's new evidence.
Member Jim?
Yeah, I want to somewhat echo what DCA is saying, that I think that what this case, the best outcome of this case is that we add to the bylaws to make it so that due process, a full due process is something that, or a lack of full due process is something we can consider in rehearing a case. But until we change that bylaw, I just don't think we can, make up bylaws on the fly as we go. And it seems pretty clear that the plain reading of the rehearing rules does not allow for a rehearing of this case. And so I think it's important, incumbent upon us to change those bylaws, but until that is done, I really don't see what we can do.
Is there any other discussion amongst members? Respondent, you have up to 3 minutes to summarize the position.
Well, I just have to laugh about due process. I believe it was Mr. Papel who said that, this committee doesn't afford due process. I believe, DCA spoke to the fact that, administrative hearings don't afford due process. Speaking of due process and changing the bylaws, there's 7 of you here. I need 6 of you to vote in my favor to win. How is that due process? Well, I've only been bringing it up for 10 years now? Isn't it amazing that when the other side speaks, you instantly bow over for their due process concerns? But when us, the citizens, the violated citizens speak, that doesn't seem to matter, at all. Also, there is new information. I still have not gotten the policies. Wow! Talk about due process for an IDR. The Ministry of Sunshine can't even get that enforced. Sorry, I am paying you the utmost deference in speaking the whole truth and nothing but the truth, Your Honor. So help me God. So, it is not I who am the failure here. It is the fact that you guys are bending over backwards for the city, being a shill for them, and violating all the citizens' rights when it comes to their due process, what they need to get to prove their cases and everything else. You go up against the sheriff's department, which can't even walk me across the street to get my medical care, which can't provide police services at San Francisco General because they're just security, which, can't find a dead woman in a hallway. I mean, you guys, how much longer does this have to go on? And mind you, the next case is going to be about my medical records, and mind you, they're going to get up and say, well, they're not.
I'm going to interrupt you.
Please.
Time back on. You are summarizing this case only, not anything else. Please stick to that.
So, like I said, when it comes to due process, I still haven't even received the policies, much less the videos. So,
Thank you.
I still have a minute left, but if you want to cut me short, please go right ahead.
Mr. Garza, do you understand that in this particular case, it would take 6 votes to rule against you, not for you, in this case? So when you say that...
That's still not due process. It should only take 4 out of 7.
No,
We're talking about due process.
Okay.
That was what it was all
I
about.
just want to make sure you understand.
The principle of due process, yes.
Thank you. Thank you. Mr. Nico?
I understand that the procedures for the task force indicate that reconsideration can only be obtained with the submission of new evidence. However, I would indicate that based on this discussion, that threshold is not very realistic and not very efficient with regard to the arguments. In this case, I can't talk to other cases. With regard to the first finding of whether or not the Sheriff's Department was in violation of the ordinance by not providing information that we had no idea Mr. Garza was asking for, should not require new evidence. If this task force made an error in its finding, in its arguments, in its determination, it should be able to reconsider that upon proper notice and petition, which it has. More importantly, with regard to the 67.29 index to records, there was no evidence presented at all to support that finding. The argument whether or not this task force can go to different violations based upon the evidence presented and based upon the arguments presented that are before the task force is one argument that I'm not addressing right now. But whether this task force can look at evidence that is not submitted in the case on its own motion, on its own accord, without any type of sharing with the parties, I think is beyond due process. It is not admissible evidence. And if this task force makes a finding that is not based upon the evidence before it, it is wrong and should be open to reconsideration. Therefore, my motion, my petition, and the memorandum behind it urges this task force to find that there's error in both determinations and rescind those findings.